Hi, I'm Bill Kirshner, an Assistant General Counsel with the FLRA's Office of the General Counsel. In this series of videos, the Office of the General Counsel is providing training on collective bargaining, one of the most complex subjects under the Federal Service Labor Management Relations Statute. This series will cover what is included in the scope of bargaining, what represents good and bad faith bargaining, duty to bargain issues, including term, midterm, and an in-depth analysis into change bargaining, addressing both what is a change and what impact is necessary to support the finding of a bargaining obligation. What defenses exist that may modify the duty to bargain, including covered by contract interpretation and times when grievances, not ULP, should be pursued. And lastly, remedies when bargaining violations occur. You will soon see that collective bargaining is one of the most complex subjects under the statute. If you do not watch the entire series, you may miss critical information affecting your ability to bargain successfully. Why is bargaining so complex? It's complex because there are three broad factors simultaneously at play in bargaining cases: scope of bargaining, duty to bargain, and defenses to the duty to bargain. Let's explain what each of these mean. First, scope of bargaining addresses what topics are generally included or excluded in the matters a union may be entitled and an agency may be required to bargain. Second, duty to bargain sets out when the duty to bargain arises. Generally, this encompasses term, midterm, and change bargaining. Third, defenses to the duty to bargain need to be examined. Sometimes it appears a matter is within the scope and duty to bargain, but for one of several legal reasons, the union does not have a right and the agency does not have a statutory duty to bargain. This video addresses concepts of good and bad faith bargaining, which apply only when the situation intersects in the green shaded area. This occurs only when scope and duty overlap and when there is no valid defense removing the bargaining obligation. When there is no bargaining obligation, as the circumstances fall outside the green shaded area, concepts of good and bad faith bargaining do not apply. This series introduces terms and concepts the OGC will raise in investigations which help govern the FLRA in adjudicating bargaining disputes. It does not represent legal advice. Now, on to the presentation. All unfair labor practices are violations of Section 7116 of the statute. Turning to Section 7116, we see an A section where A1 through 8 covers all agency ULPs. Section 7116B, B1 through 8 covers most union unfair labor practices. Some A and B subsections describing ULPs are identical. Section 7116A5 makes it an unfair labor practice for an agency to refuse to consult or negotiate in good faith. The exact same requirement to negotiate in good faith also applies to unions and is found in Section 7116B5. The duty to bargain in good faith thus is a mutual obligation, which applies equally to the employer and the union. To determine if a party failed to bargain in good faith, the authority looks at the totality of the circumstances. Both labor and management need to remember that all of their conduct while bargaining will be subject to examination and may impact the ultimate finding if one side, the other, or both bargained in bad faith. If bad faith bargaining occurs, parties may file an unfair labor practice charge in their OGC regional office. So, what is good faith bargaining? The statute defines good faith bargaining as the duty of an agency and an exclusive representative to approach negotiations with a sincere resolve to reach agreement, to send duly authorized representatives who may negotiate on any condition of employment, to meet at reasonable times and convenient places and avoid unnecessary delays, to execute, if requested, a written document covering the agreed upon terms, and to take steps to implement the agreement. Before we examine these, it's worth noting that while not addressed in this presentation, Section 7114B4 creates an obligation for an agency to furnish data to a union in certain circumstances. How does the FLRA determine if a party has a sincere resolve to reach an agreement? Remember, the FLRA looks at the totality of the circumstances. The OGC investigates what was said and done at the table and throughout the entire bargaining process. If the facts and evidence support the conclusion that a party was unwilling to discuss its proposals and question the other side about its proposals, that could evidence one type of bad faith bargaining called surface bargaining. Further, Arriving at the table with only one proposal and being unwilling to consider alternatives may also support a finding of bad faith. Both sides also need to send representatives to the table who are authorized to negotiate and to reach agreement. Of course, as new proposals may be made at the table, representatives could be authorized to accept some proposals but not others. A representative who isn't authorized to accept anything other than an initial proposal could be charged with not being authorized to negotiate. On the other hand, requesting time to consider unexpected proposals is unlikely to support a finding of bad faith bargaining. To determine if a party met at reasonable times in convenient places and avoided unnecessary delays, remember the totality of the circumstances will be reviewed. An occasional late arrival may not represent bad faith bargaining, but refusing to meet in person, meet in convenient locations, or delaying bargaining by refusing to schedule reasonable dates may support a finding of bad faith bargaining. Regarding executing a written agreement, good faith bargaining requires the parties, upon request, to execute or sign a written agreement incorporating all terms and to take necessary steps to implement the agreement. Without a written document, proving the terms of the agreement are needlessly harder. Additionally, the process of capturing ideas and creating a written agreement may reveal areas where agreement has not been reached and that need further negotiation. The process of creating a written agreement also surfaces areas open to differing interpretations, which also might benefit from clarification. The statute gives either party the right to request agreements be put in writing. Once requested, the statute requires both parties execute written agreements. A failure or refusal to enter into a written agreement supports a finding of bad faith bargaining. Both agency and union representatives owe their best efforts to place their organizations in a strong position to enforce or defend against disputes related to the collectively bargained agreement. Getting it in writing is almost always the gold standard. Before we look at some examples of bad faith bargaining from authority case law, let's look at activity that does not represent bad faith bargaining. First, refusing to make a concession does not necessarily establish bad faith bargaining. Indeed, the statute does not compel either party to agree to a proposal or to make a concession as long as they otherwise bargain in good faith. Failing to come to agreement on a proposal after engaging in good faith bargaining means the parties reached an impasse, which can be resolved by the Federal Service Impasses Panel. Make no mistake, a willingness to compromise is a vital part of bargaining in good faith, but refusing to agree to a proposal or make a concession is alone ordinarily insufficient to establish bad faith bargaining. A second example of conduct that does not support a finding of bad faith bargaining relates to refusing to engage in or withdrawing from permissive bargaining under Section 7106B1 of the statute. Now, let's explore two cases in which the authority found an agency and a union bargained in bad faith. In Wright-Patterson Air Force Base, the agency said it was not refusing to bargain over the union's proposals, but that it would respond to those proposals only after an agreement on 16 procedures for conducting union-initiated midterm bargaining had been reached. Later, the agency representative said he was real busy and that he may be available towards the later part of the year. And in a later meeting, the agency representative abruptly got up and said he had to go home without first setting up the next bargaining date. The authority found this conduct represented bad faith bargaining because the agency repeatedly delayed negotiations and insisted on onerous ground rules and concessions prior to bargaining. In sport air traffic controllers, the union and the agency were parties to a contract that was about to expire. On the day the agreement expired, the agency provided the union with ground rules proposals for negotiating a successor agreement. One of the agency's proposals was that there shall be no cameras or recording devices allowed in the negotiation room. A few weeks later, the parties met to negotiate the ground rules. The union placed a tape recorder on the table and, over the agency's objections, turned it on. The agency objected and said the union was bargaining in bad faith. The union explained it needed to record the session because the agency lied during prior negotiations. The agency replied if the union did not turn off the recorder, it would not engage in bargaining. The agency asserted that taping would slow the process, that the parties had not agreed to taping the negotiation, and that the union was bargaining in bad faith. The union replied that it had the right to record the session without negotiating the issue. Management then announced negotiations were over. A week later, the agency contacted the union and suggested the parties resume negotiations. The union said it would only return if it could use the tape recorder. The next day, the agency filed a ULP charge alleging the union bargained in bad faith by insisting to impasse on tape recording the bargaining sessions. The union asserted it was the agency that was bargaining in bad faith. The authority found the union bargained in bad faith by insisting to impasse on a permissive proposal which required bargaining sessions be recorded. This impasse precluded bargaining on mandatory subjects. The fact that the agency placed the topic on the table for ground rules bargaining was rejected as a defense because it was the union that refused to bargain unless recording was allowed. Further, it was noted that the union does not need a verbatim account to perform its role or to protect itself from false claims. Thus, the union insisting on recording all bargaining sessions as a condition of bargaining evidenced bad faith bargaining. What does the Office of the General Counsel look at when an allegation of bad faith bargaining is raised in an unfair labor practice charge? Under Section 7114, typically investigators ask, did a party refuse to consider proposals? Did a party refuse to bargain over a negotiable proposal? Do the facts establish a party was only going through the motions with no intention to reach agreement? Did a party repeatedly cancel bargaining sessions or end them abruptly? Did a party delay bargaining by frequently being unavailable to meet? Did a party insist negotiations be completed in a short time frame? Additionally, did a party attempt to impose preconditions on bargaining? Did a party send representatives to the table without authority to reach agreement? Did a party refuse to meet in person or at reasonable meeting sites? Did a party insist on negotiation by email? Did a party present its proposal as take it or leave it? Did a party refuse to sign and execute any resulting agreement? Lastly, in change bargaining cases, the investigator asks, was the union provided adequate notice of the change? Was the union given reasonable time to demand to bargain or request data? Did the agency respond to the union's demand to bargain or information request? Did the agency implement its proposal before the parties bargained to agreement or impasse? Did the agency cooperate in FISA proceedings? Remember, the duty to bargain in good faith and to avoid bad faith bargaining applies only when the scope and duty to bargain overlap and there is no valid defense. This concludes the video describing good and bad faith bargaining. The videos on scope, the duty to bargain, and defenses to the duty to bargain include material impacting determinations about bargaining in different situations. For more information, visit us online. And as always, feel free to contact the FLRA for assistance.